You there, Kathy? Shit.
Yes, I'm there.
Okay, they're on. You there, Kathy?
Yes, you're live.
Shit.
Yes, I'm there.
Okay, they're on.
Yeah. Something like that. And then questions from the floor, and and then I wrap it up.
Does he look good?
Yes.
Okay, you're on then.
Yes, I'm there.
Okay.
Folks. Okay, look, welcome to Politics in the Pub. It's a pretty important topic this evening. We're standing on Gadigal land, the land of the Eora Nation, and we acknowledge the stewardship of that land by our predecessors in the past, now, and the responsibility for stewardship in the future. That's kind of important. Well, it's not kind of important, it's incredibly important in terms of the issue about the protection of a precious planet and the stewardship and responsibility for that planet, for which we express gratitude to Indigenous people and have so much to learn from them. Now, the topic for tonight is protesters to save the planet are lifesavers, not extremists. You would know that under the process of populism and right-wing intolerance of anybody who protests the status quo, that people in the streets around the world, not just the Extinction Rebellion brave people, but their colleagues, are being regarded as extremists and regarded as people of no consequence. When the issue, for me, is the same as the one regarding Gaza. The reaction to Gaza is a test of a common humanity. How we react to Gaza is about the survival of a common humanity on this planet. And the common humanity is at stake in the protection of a precious planet. So in that respect, I'm pleased that Anastasia and David are both here to speak to that topic tonight. I've just given them both a compliment by saying that in their wonderful names, Anastasia Radievska and David Mejia-Canales, they have 8 syllables in their names, which is incredibly poetic. And we need more music, we need more poetry. Anastasia works in law reform, in the pursuit of social justice, on the demand of the need to be able to protest. I'm going to ask each speaker to say a bit more about themselves, because my introduction isn't going to do them justice. I know David is a senior lawyer with the Human Rights Centre, that he's had interesting experience with the Commonwealth and Victorian governments and issues of law reform. He's been concerned with health development, particularly with people who suffer from HIV, and so on and so on. Well, I will ask them both to say a bit more about that. Welcome to Politics in the Pub. And who's opening the? You are, David. You're up first, David.
Yeah.
Thank you.
Thank you very much. My full name is actually David Joaquin Javier Mejia-Canales, so I'm not sure how many syllables are in that. Thank you. As always, I also, before conducting any business, I would also acknowledge that we are here on the beautiful lands and waters of the Gadigal people of the Eora Nation. And I also think it's really important to acknowledge that since colonisation, Aboriginal and Torres Strait Islander communities have fearlessly used protest as a way to fight for their self-determination, their land and water rights. and an end to police violence against the ongoing structural racism that keeps them locked out of justice. And that fearless advocacy continues to this day. The Aboriginal Tent Embassy in Canberra is the world's longest continuous protest for Indigenous land rights. I just also want to note in advance that I'm recovering from pneumonia, so please excuse the quiet, breathy tone of voice I have at the moment. If it sounds like I'm underwater, that's what it feels like. As mentioned before, I'm a senior lawyer at the Human Rights Law Centre here in Sydney, and the Human Rights Law Centre, we use strategic litigation, policy solutions and advocacy to support people and communities to eliminate inequality and injustice. My work in particular focuses on protecting democratic freedoms, the right to protest, the right to vote, but also protecting democratic institutions from the corrosive effects of mis and disinformation. Just a very small task. Now, today I'll speak to you about the right to protest, what it is and where it comes from, and what it looks like in New South Wales. And then I'll move on to talk about where we've been as a community and a society and what we've been able to achieve through protests. But I'll also touch on where we go from here. Now, the right to protest is absolutely crucial for realizing all of our other human rights. It's kind of, think of it as a gateway human right. But where does it come from? The legal foundation for the right to protest in Australia comes from various sources: international law, the common law, statute, and human rights law. But I want to be clear that the right to protest is a popular term, it's not a legal one. And when I'm talking about the right to protest today, I'm talking about the right to peaceful assembly and association, which is the proper legal term. But I'll use this term interchangeably, particularly because the right to protest is kind of how we talk about protest. It's not how lawyers talk about protest. Now, the right to peaceful assembly and association is proclaimed in the Universal Declaration of Human Rights. Australia recognised the importance of it when it became a signatory to the International Covenant on Civil and Political Rights, or so we'll just call it the Convention, the Covenant, sorry, for short. And the Covenant, among other things, provides for the rights to freedom of expression, peaceful assembly, and freedom of association, as well as a whole lot of other absolutely fundamental human rights. As a signatory to the Covenant, all governments in Australia and their agencies, the police, Centrelink, all of them, have an obligation to respect, protect, and promote all of the rights in the Covenant, including the right to peaceful protest. For anyone within Australia's jurisdiction, that's not just citizens, it's absolutely everyone at all times in Australia's jurisdiction, including people seeking refuge, people seeking asylum, and even stateless persons. You don't have to be a citizen to enjoy the rights that are contained in the Covenant. Now, Australia's common law tradition, which is basically the court precedents, laws that are made through court precedent, recognises the freedoms of expression and assembly. But the common law freedoms don't give you a positive right, which is basically where the government would have to guarantee the rights in freedom of expression. They act as effectively as a bit of a fence around the government making laws that limit your right to freedom of expression or assembly. In some Australian states, unfortunately New South Wales is not one of them, the right to protest is expressly protected in legislation as a human right in Victoria, the ACT and Queensland. And in Queensland, they also have a standalone law around that guarantees the right to protest, mainly because that was a reaction to when Joe Bjelke-Petersen banned all protests at all times in public spaces in Queensland. One thing I will say about the right to protest is it's not absolute, which means that it can be limited. But the limitation has to be justifiable in a democratic society. It has to be the smallest intervention to achieve a legitimate aim. It has to be lawful, so it has to be done according to law or by an administrative decision that is based on law. And it has to be for one of the few grounds for limitations that are permissible under the Covenant. So now that we've got a bit more of a common understanding of the right to protest, let's talk about where we've been. So throughout history, pivotal moments such as the first Aboriginal Day of Mourning that happened in Sydney in 1938, which is now Survival Day or Jan 26. The freedom rides that happened across New South Wales in 1965, and the enduring legacy of the first Mardi Gras in 1978, which was a protests against police violence by LGBTIQ communities. These things stand as a testament to the power of protest and collective action over time. And when I was reflecting on the topic for today, protesters to save the planet are lifesavers, not extremists, I thought the best way to answer that proposition is to actually maybe take a step back and have a look at what's happened in the past. So about 110 years ago, museum and gallery directors in London were asked by the police to consider whether they should change their rules for women who wanted to visit their galleries. Museums actually considered banning women altogether or asking them to sign declarations that they were not going to get up to any sort of extremist mischief. And this was because at that time, there was a vicious fight raging about whether women should have the right to vote at all. Suffragettes, of course, they initially asked nicely. They petitioned the parliament. They had peaceful, open meetings. They collected petitions. They even had garden parties. And all of these things were ignored because they were demanding the right to vote. Their attempts received ridicule, and which actually led to their tactics escalating. They were mocked. They were beaten by police in public and private, and they also suffered sexual violence. Many were tortured. Many were force-fed after going on hunger strikes while they were in prison. Many were in prison for disturbing the peace. They protested so much and stalked politicians and got under their skin so badly that they implemented specific anti-protest laws to curb their advocacy. You tell me if any of this sounds familiar. One suffragette even famously broke into the Houses of Parliament and hid in a closet in a crypt during census night in the UK because she wanted her address to be the Palace of Westminster in the census. And so it is. You can go view it. Her address is listed as the Palace of Westminster. Suffragists risk losing their jobs, their children, their marriages, their inheritance because of their extreme protest, and yet they persevered. In March 1914, Mary Richardson entered the National Gallery in London and attacked Diego Velázquez's The Roque Being Venus. She screamed as she did this, "It's time for deeds and not words." She was arrested. Today we take the fact that votes for women is just granted and that's just the way it's always been, but that's not the case. The right to vote for women didn't just materialize. It wasn't a gift from Parliament. It wasn't a gift from politicians. It was fought for, and many women died for it. These extremist women, as they were deemed at the time, were only demanding to be fully included in their society. Once all polite, pleasant avenues failed, their tactics escalated. I think that it's clear that who or what we consider extremists today changes as society changes. I imagine 100 years from now, people, great-grandchildren will be scratching their heads wondering why we did that to climate protesters in 2024. So where are we now? So as already mentioned, governments have a duty to facilitate peaceful protest under international human rights law, including by ensuring that people are not prevented from exercising their rights by police or by private companies. Governments must also ensure that any restrictions on protests are limited to what is strictly necessary and proportionate, but that's not what's happening here in New South Wales. In the last 20 years in New South Wales, the New South Wales Parliament has passed 7 anti-protest laws with some of the most extreme punishments for these types of laws anywhere in the country. I'll talk about the most recent example, which is the Roads and Crimes Legislation Amendment Act of 2022. That act undermined the ability of everyone in New South Wales to exercise their freedom to protest. The laws deliberately target protesters, threatening everyone from school children marching for climate action to anti-war protesters with up to 2 years in jail and a $22,000 fine. And it's criminalising obstructing public spaces or also obstructive kind of actions that happened on major infrastructure as well as roads. Blocking a road is a very easy offence to do. You just walk out there and that's it, you block the road. But that shouldn't attract a $22,000 fine. The problem with the law is that it is so vague and ambiguous that it actually makes it more likely that the law is going to be applied inconsistently, misapplied, or even misunderstood by the police in practice. In the protest context, the risk of an unclear law is that protests will be prevented or ended before they should be, or that people who do take part in what we would consider quite benign peaceful protest action are then criminalised with a $22,000 fine. or up to quite a lengthy term of imprisonment. The risks posed by these really unclear laws are compounded when their penalties are disproportionate, like the one here in New South Wales. So what is the solution? I mean, firstly, all governments and their agencies, as I mentioned before, have to accept that they have a duty to guarantee the right to protest for everyone at all times. This includes preventing others, like the police, from interfering with or violating the enjoyment of their rights. Governments and their agencies are also required to protect all forms of peaceful protest, regardless of what form it takes or where it happens, including online, in the streets, in public, or on private land. These protections, again, are owed to all people. Governments also have to accept that public protest involves some level of temporary disruption. That's just unavoidable because it happens in public space. International law protects disruptive protests, provided that they remain peaceful. So it's peaceful protest that is protected at law. Temporary disruptions that are caused by protests do not undermine the duty that governments and their agencies have to guarantee the right to protest. So tolerance to disruption to ordinary life is necessary in a democratic society if our rights to peaceful protest are going to actually have their full true value. Governments must also act in conformity with the law if the right to protest is going to be limited, and that just hasn't been happening. As I mentioned before, the right to protest can be limited, but only when it is necessary and proportionate to do this. Now, how do we make sure that governments act this way? New South Wales needs a human rights act. Yes. And a human rights, thank you, agreed. Won't surprise you to hear that a human rights lawyer is advocating for a human rights act, but a human rights act is essential to the practical realization of all of our human rights, to ensuring that human rights ideals and commitments guide all government decision-making and empower people. Such an act would set out the rights which our governments must consider in lawmaking, respect in public service delivery, and also in any actions that they take, and to which our governments can and must be held to account. But I think more importantly, in returning to the main message of today, that protesters to save the planet are lifesavers, not extremists. I think it's absolutely critical that we all push back on any attempts of any parliament, police service, or politician that demonises protest, in particular environmental and climate protests. We should always push back against any attempts to demonise these things, because every time that the protest is demonised, it also demonises the many wins that we have won via protest. So many of us owe our human rights more to protest than we do to politicians. And who we consider extremists changes as society changes. And I would argue that climate defenders are probably doing all of us a favour by keeping this issue on the table, by highlighting injustices, by getting in the way, sometimes quite literally, of new or expanded colonies. Protest is not an aberration of democracy, it's actually how democracy is meant to function. Climate protesters, like the suffragists before them, are only taking more public and visible tactics because everything else has failed to achieve the action that is needed. Recently, the Rugby Venus by Velasquez was attacked again. 2 climate activists protesting new oil and gas projects in the UK hit the protective glass covering with a painting with small hammers about 10 times. As the activists did this, they yelled, "That deed, not words." So as you can see, who and what we consider extremists changes as we change. And any person who takes peaceful protest action to save our planet right now, as it is quite literally baking, is only doing all of us a favor. Thank you.
Well, for somebody who's just recovered from pneumonia, I wonder how much more powerful you would be if you didn't have pneumonia. But thank you. Anastasia, that's a cue for you to come to the microphone.
Thank you, Stuart.
Well, thank you.
Thanks so much, David. That was a hard act to follow. I'll do my best. Hi, everyone. For those that don't know me, my name's Anastasia. I'm here as a protest rights campaigner for the Australian Democracy Network. but I also wear a few different hats in the movement. I'm part of Legal Observers New South Wales, which is an organisation that works to defend the rights of protesters here in New South Wales, and also I'm working in a couple of other coalitions around this issue. Is that all? I want to start off also by acknowledging the contributions of First Nations activists to the climate movement, and the fact that here in New South Wales, First Nations people are leading the fight for our climate. So in Narrabri, Gomeroi elders are fighting against the continued expansion of the gas pipeline there. Across Australia, Tiwi Islanders in New South Wales are fighting against Santos there as well. And it's quite telling that we are really only battling, you know, 2 or 3 leading all of these projects. And there are people in the rural communities, and all of us care about climate, to come by. The protest issue is actually such a power. Like David said, it's an enabler. So it's something that has, while it's used to talk about this here today. And it was funny, I was reflecting on the way here, how last time I spoke at Politics in the Pub, when that was happening, I was getting ready with my little speech at Hotel Harry, which I accidentally had to before coming here. And I got the news that a campsite in the Blue Mountains where some climate activists were camping had just been raided by a team of undercover police officers, some of whom were believed to be counter police, who were spotted to be hiding in the bushes in their gillyweed suits, and then promptly accused protesters of assaulting them for gently asking them who they were and what they were doing on private property. So some of you might remember those raids against Blockade Australia in the Colo property, as a result of which around 20 activists were charged with a variety of offences for which they had to fight in court for several months. And today, as I stand here, I'm coming to you guys off the back of supporting some of the people arrested at Fort Botany on Sunday. 19 people arrested for spending about 10 minutes on the road in front of the port entrance, brutally slammed to the ground, several people having their hands bound so tightly that they went numb, several people with extreme bruising, scratching, and also police, homophobic police behavior towards people in custody, just all the tick boxes of police brutality. And again, charged with the anti-protest laws for, again, a 10-minute sit-in on a road. So this sort of deja vu has got me thinking about how the protest landscape has been changing in the last 2 years, and what relevance the mobilization of the state against climate protesters has to all other movements as well. In the sense that I think that when the anti-protest laws were introduced, and they were introduced particularly to target climate protesters, Fireproof Australia and Blockade Australia had done actions right in the lead up. They had blocked Fireproof Australia had blocked Spit Bridge, which is blocked several times a day because there are yachts coming through it. But apparently we can tolerate disruption for super yachts coming through, but not for our climate. So this legislation was very much targeted towards these climate extremists, eco-terrorists, whatever terms are thrown around. But I think reflecting on where we find ourselves today, we see how quickly the term extremist really expands once it's introduced into our lexicon. And as soon as these protest laws are brought into the police's tool basket, you know that they will use them against all kinds of movements, as is happening now in relation to the pro-Palestine movement. And even within the climate movement, I think it's interesting to reflect on how a lot of these mobilizations that the laws were targeted towards, they were positioned as groups that had kind of a direct action, quote unquote, extremist approach that, quote unquote, normal protesters did not adopt. So there was this real line that the New South Wales government and Ben Fordham and all their ilk attempted to draw between your kind of mum and dad climate activists and the activists to go out there and block ships. And I think that what's really interesting about the anti-protest laws is, in a way, they have cemented how those protesters are actually bound by more than they think, in the sense that these anti-protest laws have also now begun to be used against protesters who do everything right. So who negotiate with police, who go to police and tell them what their plans are, who try and make the protest as non-disruptive as possible within still having impact. So an interesting example of this is the Rising Tide protests some of you might have heard about in November last year, an amazing mobilization, over 100 people on the water, blocking our largest coal port. And these were protests that were carried out in a way that had extensive police negotiation, very, very accommodating towards police demands, and were in fact in some ways facilitated by police. But as soon as people stayed on the water beyond the 30-hour period that police had allowed them, within 30 minutes, they were all being dragged off violently in their kayaks and being taken to the station and being slapped with charges. And not only were their arrests violent, but the way that they were punished through the criminal process was very, very similar to what we saw in relation to these more extreme direct action activists at Colo. So in the same way that those activists got bail conditions preventing them from associating with each other and preventing them from associating with Blockade Australia as an entity, the protesters at Rising Tide had bail conditions that included not associating with any protest movement at all, right? So that included things like social media. So you couldn't go and a post by Greenpeace, for example. It included things like on their bail sheets, and this was just, funny bit of police incompetence. They had listed, you can't associate with COP28, which some of you might know is the international climate conference that Australia is part of. So banned from associating with that protest. And also banned from associating with any quote unquote issue motivated groups, which is an interesting bit of terminology that has become increasingly common in New South Wales police documents. And when questioned about what this group meant, what issue motivated groups mean, New South Wales police said, well, it's groups that are motivated by a cause, an issue. And they basically have said that they keep tabs. They have a surveillance unit of 8 police officers that keeps tabs on issue motivated groups in New South Wales. And of course, they refused our request to give us a list of what those issue motivated groups are. So we can safely assume now that the situation as we have it is that anyone who participates in any cause-related organizational activity is potentially on a list that is held internally by New South Wales Police with no transparency, whose activities are being surveyed, and that you will be banned from communicating with any cause-related issues if you deign to exercise your democratic right to participate in protest. Now, I don't want to be overly, doomerist about this in the sense that those conditions were varied by a magistrate pretty much as soon as they were brought before a magistrate. But the fact that the police feel that they have the space to operate within, to actually bring those conditions forward in the first place, and to know that that there's no internal police culture around respecting the right to protest, obviously. I think that is something that we should really be thinking about in terms of when we think about these protest laws or these bail conditions or policing. What we see is as soon as we allow them to be introduced for extremists, we allow them to be introduced for everyone else, for community groups that are cooperating to the best of their ability, community groups that want to have even non-disruptive protests. They are falling foul of all of these laws, and they are placed in the same basket as direct action activists. And I also want to just make sure, as I'm saying this, that we respect and acknowledge and really celebrate the role of direct action in our protests. One of the key points of the Declaration of Our Right to Protest that Human Rights Law Centre has created is that the right to protest encompasses the right to disruptive protest. Disruptive protest is absolutely crucial to the point of protest itself. Otherwise, it's just a symbolic expression of something that is already government-sanctioned activity. And I think that it's really interesting to look at the way that, for example, governments have talked about different kinds of fundamental rights and principles. So Chris Minns, when talking about the Pop Botany protests in November last year, evoked the fundamental principle that trade cannot be disrupted. I don't see that in the Universal Declaration of Human Rights. But what I do see is the right to assembly and the right to democratic expression. So I think it helps to be really careful about how the language of rights gets co-opted and how the language of particularly things like peaceful protest, also gets co-opted by the state, because what you will hear from governments and from media is we support the right to peaceful protest, but we don't want to be 5 minutes late for our appointment. And this kind of distinction, again, erodes the solidarity that we can so powerfully have across communities when we come together in support of the right to protest. I want to talk briefly as well about the ways that New South Wales police and police around Australia have attempted to cut off people's capacity to protest through intimidation, because I think it's really important to name this as another tool in their basket, and a tool that is applied, you know, to counter-terror operations as well. We're seeing increasingly police adopt tactics that parallel the kinds that are used for people organizing terrorist acts, but they're using them against climate activists. So, for example, we've had instances of police visiting the homes of activists in the lead up to planned protests with an intimidatory sort of sheet saying, did you know that if you go to this protest, you will be committing an illegal act? So over 100 people got visits like this at the end of 2022 in the lead up to the IMAC conference in Sydney. And this often, it passes under the radar in many senses because this is so normalized in a way, and police can play that card of, well, it's for community safety and we support the right to protest. But really, if we look at it objectively, getting a knock on your door at 10 o'clock at night from 2 police officers telling you might be doing something illegal if you join a protest, I don't think that most Australians think of that as something that happens in this country, but it is, and it is getting worse. And once again, you know, if we are allowing that to happen to certain kinds of activists, we are allowing it to happen to ourselves in relation to the causes that we believe in. I think also I would like to acknowledge, even at the moment, that while there has been a lot of mobilization around this issue in civil society and across union bodies, we still have a long way to go in terms of speaking out about this issue. Like, for example, I think I haven't heard any statements from, I guess, from many of the groups that I would expect to hear statements from in relation to the imprisonment of Violet Coco and Brad Homewood in Victoria for the XR protests 2 weeks ago. And I think that is for a variety of reasons, but I think it's really great to see the mobilization that is happening in relation to, for example, the Port Botany protests, even on Sunday. We've already had over 15 groups sign up to an open letter speaking out against that repression. So I think that many of the ways that we approach campaigning on this issue, there are a lot of structural limitations that many of us are working with. And there's a certain narrative that we're working with that doesn't necessarily lend itself to solidarity. But I think one of the things that we can do to fight for the right to protest is to say to the people in our lives, to the people in the community groups that we're in, this is why the right to protest matters. And it matters both to me as an individual, and it matters to the things that we jointly cared about, as David has so brilliantly said. So I think one of the things that I would love for people to take away from this is to be able to talk about protest as something that is actually a fundamental principle, that is actually part of what makes us citizens, and to be able to be very clear-eyed about how quickly repression and the acceleration of repression really happens. Even, as I said, between my last appearance here and today, this last appearance was about 2 years ago, we have already seen a worsening in who these laws are applied to, how often police are pushing the boundaries. And I really encourage everyone to speak out as much as possible about this, to share these stories of repression, and to talk up about the value of protest, because it really is the fundamental key to all the other fundamental things that we value. Thank you.
Well, Anastasia, thank you for your stamina and for your courage and for your commitment on this important issue. I'm going to move straight away to questions, because otherwise we lose momentum if we start saying people can spend 25 minutes going to get a drink. Let's move straight into questions to either or both of the speakers. Yeah,
Hang on, wait.
there's a microphone.
You don't want to be on camera. Go on.
Talk about hormones and how you view them, and particularly how you view them in this current climate where it's being cracked down, particularly even family friendly. What's the, do you see it as a huge trend? Should we be learning?
Yeah, thanks so much for that question. It's a really pertinent one. For those that don't know, the Form 1 regime is a part of the Summary Offences Act that was created after the initial Mardi Gras riots to allow some offences to have a defence of prior notification to the police. So if you're obstructing a road and you let police know that you're going to be doing that and police don't oppose that, then you're protected from the offence of obstructing a road. And the Form 1 regime is really important right now in relation to the anti-protest laws because the government has invoked these Form 1 protections as providing a defense for people who want to engage in protest in quote unquote the correct way. So it's another wedge that's being driven between different kinds of protest communities. I think that speaking with my legal service for a moment, we have seen so much misrepresentation and abuse of the Form 1 regime that I would say that it functions much more to restrict and corral protests than it does to facilitate it. We've seen, police misstating the amount of time that you should give a notification within. We've seen police misstating the effect of the Form 1. We've seen it be used to pressure organizers to adopt certain conditions around the protests, like not making too much noise or not having certain kinds of signs. So it really is wielded as a tool of control rather than facilitation. And although in the sort of judicial statements about Form 1s, there is some overture around police having to approach the Form 1 process from a spirit of facilitation. But that is clearly antithetical to their interests, because what we're seeing now is because police are adopting flexibility policing in relation to protest and mobilizing 100+ police for even the smallest protests. Sometimes I've been to protests where there's more police than protesters. What their structural material interest is to not allow protests because they don't want their officers placed on that duty. So it creates this quite absurd situation where police don't want protests to happen because they will take up too many of their resources, even though those resources are not necessary at all for the protest to be held safely. And then they are combating the right to protest through this Form 1 process. So I think the Form 1 process is highly problematic, and I'm aware even now of a campaign beginning to form against it. And I will just say that Victoria actually just resoundingly rejected, Jacinta Allen, the Premier there, rejected bringing in a permit system similar to the Form 1, despite police lobbying just yesterday. So I think that gives us hopefully a little bit of leverage with Labour here to try and, if not completely abolish, then at least create some safeguards around the Form 1 regime so that it is truly a tool of facilitation rather than control.
Thank you. I'm absolutely agreeing with everything that's been said. I think the problem with this sort of notification, they're called notification regimes and international law, is that they're being used as a way to authorize protests. And that's the problem, in that notification regimes, if they exist at all, they have to be under, to facilitate, the notification of police, the protest is going to take this route over that route or whatever. People should not be compelled to use them, because it is an absolute farce to ask the government permission to protest the government. That in and of itself is ridiculous and is an affront. And what we're seeing in New South Wales is that these sort of notification processes are actually becoming authorization processes de facto. And even the way that governments talk about unlawful protest, there's no such thing as an unlawful protest. It doesn't exist at all. However, because if someone doesn't submit these forms, it doesn't go through the whole rigmarole of asking the police for permission to protest the police at times, then it becomes a de facto system of authorizing protest. Actually, going through the process becomes an end in and of itself, as opposed to actually facilitating protest. So any attempt that we have to ask the government to protest the government in and of itself undermines the right to protest fundamentally.
Okay, thanks.
Grab it. Grab it.
You just got me with the Form 1. I wasn't going to ask a question, but so I've done a couple of Form 1s in my time. So I was interested you said Victoria doesn't have that. I didn't know. So this is the unique, well, question I'm wanting this unique to New South Wales or other state. And then two, in a couple of instances where I've done the Form 1 and, been polite and worked with the cops and all that sort of stuff, I've had a couple of occasions where, 24 hours, I can't remember the timing. I think you tell them 7 days in advance, and they've got a week to, you're right, authorise. And so I've had the authorisation, and then either like very close or actually when we're there, for their operational reasons, they've tried to stop me or stop us in relation to the protests. One of them was that week of the climate action. We were doing a big teachers' protest, and the cops were freaking out because of that climate action, whether people run those streets and stuff like that. Anyway, so that's the second question. So you get authorisation. What legally, if I didn't go with it when they say 10 minutes notice you're not allowed to do it, what's the legal ramifications for someone who signed the form?
I'll answer the first part, given you to use as taxation at the same time. Excuse me, I feel like I'm just running around. But New South Wales is not the only place or the only jurisdiction with these types of notification processes. They do vary across the country. Victoria doesn't have one. In Tasmania, for example, it's just you just email the police. Like there isn't a set form, but it is at their full discretion. Thank you. At their full discretion as to whether they authorize it for you, and they can impose conditions that you haven't even considered. So recently we saw one where the police asked a small community group to provide public liability insurance. And they're not going to have that at all. But then that becomes a condition on you exercising your right to protest. Very recently we had a case in the Northern Territory. The permission actually goes to the local government area. And there, the city of Darwin asked First Nations communities to pay $8,000 before they could have an Invasion Day protest. So that money was for managing traffic around the protests, which in and of itself is ridiculous. I mean, one of the other things that the covenant guarantees is your right to public service, regardless of who you are. So these things are not, they operate very differently. And at the Human Rights Law Centre, we are considering these things because they become a way of authorising. The Form 1 gives you immunity from some criminal kind of offences, but it doesn't mean that your protest is somehow not allowed to continue. And the variation of the actual conditions on the day, like Anastasia said, this is very much more knowledgeable.
Yeah, so the way that the conditions of the Form 1 regime operate is that it is somewhat true that you have to give the notification 7 days before, but the way that it actually functions is that if you give the notifications more than 7 days before the protest, police have to go to court, have to take you to court in order to oppose the holding of that protest within the conditions that you have set. So you're not actually obliged to negotiate with them in terms of how that process takes place. People normally negotiate because they don't want to get taken to court. If you apply less than 7 days before the protest takes place, then you have to, and police oppose it, then you have to be the one to take police to court to get that first. So the difference is the onus of who is bringing the evidence that the protest shouldn't go ahead. Now, the question of negotiations and conditions, it's a strategic question in the sense that if you want to avoid police not authorizing the protest, it makes sense to negotiate. But at the same time, they do have duties within that have been elucidated in the common law around the cases around this, to negotiate fairly, to only apply conditions that strike a reasonable balance between the right to assembly and the convenience and enjoyment of the general public. They have a duty to protect the freedom of public expression. And all of these questions, they exist in law, but they very rarely exist in practice, because many people, when they're going up for the Form 1 negotiation, end up feeling very intimidated, justifiably, because you're in a room alone with a police officer who's telling you that you might be doing something illegal if you don't do exactly what they tell you to. So this is where we see this real difference between protections and law and protections in practice. This is part of why, why legal rights education is so important, but it's also part of why we can't rely on the black letter law to protect the right to protest. It has to be actually enshrined within the principles of how these things happen, and there has to be real recourse for when police don't act in those ways that they're meant to, because at the moment they are operating impunity. On the question of conditions changing on the day, the conditions are those that are agreed upon in writing between yourself and police. So if they try and vary that after the fact, that's them trying to vary it. You don't have to comply with it. As long as the protest is held substantially in accordance, which is the wording in the legislation, with the Form 1, that is sufficient. Now that is yet another weasel that they use, is they will often try and rush organizers into sticking to the exact time schedule given for the protest. So if a speech is taking 5 minutes longer, they're going to say, you're not within your Form 1, you're not substantially in accordance. Wrap it up, come on. And that is another mode of using, again, the Form 1 protest process to control and corral protests.
Okay, two questions. Firstly, how does the judicial system view protests? So, for example, police, what you're describing essentially are intimidation tactics. How does the judicial system deal with, for example, the police abusing their powers? Are they conservative, understanding, progressive, or up for times? Secondly, in the past, I heard an interesting comment, a very interesting summary of especially Australia, around various issues, including protests. We tend to be violent towards the non-violent, but we're non-violent towards the violent. Now, protesters, on average, are often our eyes and ears on issues that our newspapers, for example, our media servers of the past, have lost the influence, are not around anymore. And yet, when it comes to, for example, say the police or the government acting in terms of, like you mentioned, the inconvenience of being 5 minutes late, how do we justify violence, for example, towards people raising issues that others are either too scared or aren't even aware of it? Whereas the people who think that they're in power, if they actually lose their credibility, they actually setting the seeds for long-term, for example, upheaval from below. It's actually a lot harder to harness in the future than what it is now. So can you give us a bit of a background in terms of these two issues? Thanks.
Yeah, that's a small question. But a really important one, I think. I think in terms of the courts, for when you're sort of fronting up to the magistrates' courts, or even sort of looking to kind of have these really onerous bail conditions removed or changed somehow. Sometimes it can actually be a luck of the draw as to what a magistrate can get. Very much so, and that's not how it should work. That's not justice, but that's what the criminal legal system looks like here. Courts, the higher up you go, like the High Court, for example, has absolutely established the right to, well, it's not the right to protest, really looking at the implied freedom of political communication. The High Court searched high and low in the Constitution to find them. And what that basically, the implied right to freedom of political communications, it's not a positive right, so it's not a right that you yourself have. It's basically a right to curtail executive action on your ability to communicate political matters. And the reason that they found this in the Constitution, because that right is not in the Constitution, that's what implied right. And that is because the Constitution establishes a system of responsible and representative government. And if we're going to have a system of responsible and representative government, then freedom of political communication is absolutely fundamental for people who are making decisions to kind of keep upholding the constitutional system in place. That doesn't help you on the ground, though. You know, these things that go into the High Court, it's not only kind of quite lofty, it's unbelievably expensive and requires an incredible amount of resources and time and an army of lawyers, quite frankly. So I think that most people, when they're wanting to sort of exercise these rights, where the limitation actually comes from is actually from the police. Courts are quite sympathetic, certainly the hierarchy go, for upholding these rights because they're so fundamentally important. But I think in the lower courts in particular, there's such a lack of interest or perception that this is not their job to consider fundamental human rights implications in arguments. I mean, how many times have many of the people that we kind of work with or represent or what have you, fronting up to courts, making human rights arguments where the magistrates, like, you know, just sort of dismiss them, like, that's not actually important. You've actually committed a crime. We don't really care about your human rights arguments here. And I think that's wrong. It's fundamentally wrong in so many ways. Finally, I think, you know, maybe it probably doesn't even answer your question fully, but I think that in many ways, some of our politicians actually view the right, actually seeking to protect the right to profit more than the right to protest. And I think that's really critically important. It's just a ball. It's so great. In South Australia, the worst in terms of penalties, financial penalties, South Australian anti-protest laws were only implemented because one person was dangling off one bridge at the front of a big oil and gas conference. It is maybe no coincidence. I wouldn't want to sort of link these things together, but the brother of the Premier of South Australia is the head of corporate relations for Santos. I wouldn't want to link those two things. I wouldn't want to do that. Other people might. So when you actually start looking at all these things, you know, we're actually up against not just our parliamentary politicians, but we're actually up against an incredibly well-resourced oil and gas lobby, particularly every time that these sort of laws are introduced, these anti-protest laws, a lot of them are actually introduced in response to or as a fix to climate and environmental protests. And they haven't just sort of materialized out of nowhere. We know that business is lobbying for these sorts of things. We know this. But we actually don't have the fundamental things in our laws, whether it's for transparency in lobbying, for example, whether it's political donations disclosures, like we don't have any of these things. So in many ways, the right to protest is our actual last bastion to resist. And I think that's why it's being repressed so much, because it is effective and it is working. Otherwise, we'd have a whole lot more oil and gas fields by now.
I don't think what to add. I guess I would say on the judicial point, I think many magistrates seem to be baffled about the amount of resources being used on these protest matters, particularly when you see these quite intense bail conditions imposed by police that you have to then bring a variation against and take up court time with. When you see charges being pursued by police that are way below the threshold of what they could be pursuing. To give a recent example, the arrestees at the Popwani action in November were negotiating to have their anti-protest law charges dropped, and the police prosecutor actually wanted to do that, and then got a call from higher up in the force that was not a politically sound decision. So they're now proceeding with the anti-protest laws, which will take about a year, given the court lists. I think New South Wales courts are, you know, full to the brim and do not need to be clogged up with police, you know, basically having lording over their capacity to control people. I would also say in relation to the point that you made about violence and non-violence, I guess I would like to speak a little bit about the way that protests have increasingly been labeled. Any kind of disruption has been labeled as violent, and the increasing kind of the creep of the sort of the shadow of violence over any kind of protest that merely causes fear or merely causes apprehension. I mean, we even saw last week there was a protesters who shouted out something to the effect of ceasefire now during question time in New South Wales Parliament, as well as in federal Parliament. Several MPs said that they felt unsafe. Well, how do the people of Gaza feel? So it's, I think one of the questions for us to ask about these definitions of violence and non-violence is, well, what about the violence of the state in destroying our environments? What about the violence of the state in exterminating people? And how is it that the language of violence is wielded against those resisting those causes rather than those causing it in the first place?
Okay, I'll take two more questions.
Can I ask? You mentioned the idea of the Human Rights Act. New South Wales doesn't have one. So do other states have them? All of, not all of them.
Wait.
And can I ask another question?
Yes, of course.
It's about a protest on Sunday night at Port Botany when people were then taken off the road. Was that because, as you said, they've extended their time? I mean, who the hell is going to be driving that road at 9:30 at night? I mean, you know, I know what it's like there. I've been there.
I'll answer the question about the human rights quickly in Anastasia. But there are 3 jurisdictions in Australia that have a Human Rights Act. That is Victoria, the ACT, and Queensland. And also, at the Commonwealth level, the Attorney General, Mr. Dreyfus, has initiated an inquiry to consider whether we should have a Human Rights Act at the federal level. And that inquiry is due to report back in a couple of days. One of the things that I've found in looking at laws as they have been the anti-protest laws, I'm speaking about here, when they've been created in jurisdictions that have a Human Rights Act versus one that don't, is that they look quite different. For example, Victoria, the laws are still terrible, but they're actually confined to very specific places. So it's about logging groups in particular. Whereas in New South Wales, the most recent anti-protest laws were made in 30 hours. So from the moment they entered Parliament to the moment they became law, it was only 30 hours. There was no consideration for human rights impacts on these laws, and they were made as a matter of urgency. And those laws criminalise you blocking a road anywhere in New South Wales. So there's laws where we don't have a Human Rights Act. The laws are usually more broad, they're vague, and quite difficult to apply compared to jurisdictions that do. The South Australian anti-protest laws passed the lower house in 22 minutes. But all MPs hadn't even been given a copy of the laws before they passed. In Victoria, that's actually not as possible because there are so many steps that have to be considered for the human rights implications for any legislative intervention. So New South Wales, as well as the Commonwealth, needs a human rights.
I'll speak briefly just to the one question. So the signature place for the road is the entrance to the Patrick's Courts. However, so there is the potential of traffic moving through there, but I will note that I was there as a legal observer. We didn't see any traffic backed up. We didn't see any actual obstruction of the court taking place. And this is, it's going to be a live matter before the courts, so I don't have to do so too much. But yeah, I think the real question with a lot of these laws is the extent of the punishment, which is not only in the maximum penalty, it's in the months and months that you spend on bail conditions, in all of the court appearances back and forth, having that hanging over you, potentially in legal fees. The process becomes the punishment, and for what? For, as I said, like disruption that can often be negligible. That's not to say that the disruption can be significant, but oftentimes the extent of the impact on these protesters' lives and on the movement as a whole, their capacity to continue participating, because as I said, often they get banned from even communicating with protesters. let alone going to protest. The calculus of that versus the actual disruption caused just doesn't seem to add up at all.
Yeah, I'm going to roll with that, but just because the announcements about the next events have a direct relationship to what Anastasia and David would be talking about. I mean, in a month's time, we're going to be, the topic is about why the members of the Labour Party and the Liberal Party are almost indistinct on issues such as human rights. The next massive issue concerns tomorrow, when I gather in the London High Court, the decision about Julian Assange's right to appeal. I mean, one of the great hero protesters of our time is going to be Malcolm. So we have our fingers crossed about that. I'm aware that, you know, at any day of the week, there are tens of thousands of people who are knocking on doors about health, welfare, justice, transport, housing, asylum seekers, refugees, and getting nowhere. They're being strangled by laws, they're being strangled by bureaucracy, almost as though the laws or the means of prevention become institutionalized. Now, I'm going to finish on an optimistic note. I mean, I've been coming along with Peter and Stephen and Mary and others, and Frank, to this famous public institution for a very long time. I'm always amazed and grateful for the enormously high standard of speakers such as David and Anastasia tonight. We're grateful to both of you. You've addressed important topics in ways which I'm sure all of us will benefit. So thank you for coming and thank you for what you're doing.
Thank you.
You've got to answer. No, you're not allowed to. No,
I'd like to invite you both to speak at my court hearing on the 6th of August. I was going to test everything you were talking about, the freedom of right to whatever it was, the implied right to free speech. We're putting, it's very small, it's almost funny, we're putting the Effen massacre order on the spot. Yeah. So it's almost funny. I'm retired, so I don't care all the process. I love the process. It's so funny, and I'm very lucky to have like O'Brien lawyers before that, the wonderful Mark Davis before that. So like this is a real education for me, and it's good and it's great. And we've got to be on the front foot. I always think of Peter McGregor. I don't know if some of you remember him. And he always said that, you know, you have the rights that you fight for. It's not, you know, they may be written down, and that's a good thing. But unless you fight for them, they're not really there. And we have to push back against the Form 1, particularly, I think. That's like a thin end of the wedge. Like, I've been to protests, and they're so friendly to the police. Sorry, thinking that they have to get on the right side. They're actually, I put a banner up in the wrong place, they think. They have called the police to come. They wouldn't have been there unless they called the police. This is one a fellow protester to come. I mean, it's all upside down. We've actually created this culture of protest that we think the police are there to. We should be in the place of the police. We've signed a document. It's bizarre. And so the police came and took down my banner at the behest of my fellow protesters. Anyway. So sorry, I lost where I was going. So please come on the 6th of August and sit outside the band.
Okay. You want to say?
no, I think that's.
Thanks, everyone. Okay. Okay, Kathy, I can close down. See ya.